Good morning, everyone, and welcome from the London office of HCR. Apologies if you can hear the background noise. It seems the entire of London is under construction just as this is going on. It certainly wasn't like that at 7 o'clock when I was here, but yeah, very sorry about that. So yeah, I'm going to be looking at supply chain issues, certain red flags, how you can try and avoid issues when you're in supply chain, or at the very least put you in a good position if any of those issues arise. We can presumably assume that everybody's going to be speaking about COVID and Brexit today. Unsurprisingly, both very key issues to your supply chain as well. Move on to the next slide, please. This just something for you to bear in mind throughout the rest of my presentation. Amazing figures, which I hadn't completely appreciated until I started putting them together. Those are billions. That's zeros. It took me a long time to type those zeros. And I think all in all, the government has handed out something like 350 billion of support in terms of loans, flow, VAT, business rates relief, deferrals, various support grants, etc. A quite startling sum of money. When you consider that there are 6 million-ish small, medium-sized companies in this country. They contribute 90% of UK GDP. They employ half the population. What does the post-COVID landscape look like? Who is paying the bill? Unfortunately, as you all know, we all are. At some point in time, there's going to have to be a readjustment. Reviewing Rishi's budget, I can't honestly say where it was in there that this 350 odd billion is going to be repaid. But we know that if it's not in this budget, it'll be in the next one. And there is going to be uncertain economic times ahead. Each of those companies that I mentioned that have taken on these support loans are going to have large, significant accrued liabilities, which we need to be aware of. You have the loan schemes themselves, which, although on very favourable terms to the lenders because they're backed by the government, still need to be repaid, still need to be refinanced or restructured at some point in the future. Alongside that, a lot of tax has been deferred, but not forgiven. So HMRC will be in touch with lots of companies over the coming months to try and renegotiate the payments of those. And then similarly, one of the other large liabilities, landlord liabilities, your rent, which a lot of people haven't been paying over the last 12, 18 months, is still there, still has to be dealt with. And although there are legislative changes, which we deal with shortly, isn't going to go away. Some of you may have heard this phrase zombies before. It's a interesting, horrifying terminology which came out of 2008, the recession 2008, which suggests that there are a large number of companies which are stagnant, sort of burdened by too much debt, over leveraged, and aren't ultimately economically, don't contribute economically to the overall UK economy. The idea is that we do actually need to clear through these companies, even if that involves making some hard decisions, and then using the money that's recovered to invest in otherwise profitable and growing enterprises rather than these stagnant businesses. We can anticipate, and we've already seen examples of it, that there'll be an element of debt forbearance and forgiveness still going forwards. The government in particular, I suspect, isn't going to be too trigger happy. There's a suggestion that the government, which normally files the most number of winding up petitions each year, as you'd expect, in relation to tax arrears, has something like 40,000 accounts under review by the winding up team, with a view to progressing some of those more imminently than others. We haven't yet seen that in the winding up statistics, but all indications are that over the next 6, 12, 18 months, that is going to be a big issue causing distress in various supply chains. The government has been good, however, in bringing about new legislation and new regulations. The very long debt respite scheme, breathing space moratorium, mental health crisis moratorium regulations 2020. It's probably easy enough to figure out what it means. Is one example of legislation brought in to try and encourage an atmosphere where people discuss debt issues and try to come to some form of agreement rather than just necessarily going straight to enforcement and we're trying to recover their money immediately. Similarly, the corporate governance insolvency Act 2020, and very recently the Commercial Rents Code of Practice trying to achieve the same thing, trying to encourage parties to negotiate and consider proposals rather than immediately taking enforcement. You may find it surprising, but despite the 2 years of economic difficulties, we haven't yet seen a large increase in insolvency rates. That's slowly turning a corner as all of the government support packages are coming to an end. And we really anticipate in 2022, 2023, that insolvency rates are going to increase quite significantly because having been at a historic low for so long, the backlog alone of companies which would ordinarily have gone into an insolvency process should be quite significant. And then secondary to that, some of you may have seen the murmurings from HMRC along these lines. They are aware of serious allegations of fraud in relation to the furlough scheme, in relation to the loan schemes, and they are hiring new specialist teams who are going to be looking at this in a lot of detail over the coming months. And there is a genuine realistic concern, I think, that there will be a secondary increase in insolvency rates resulting from HMRC's particularly aggressive pursuit of fraud in those particular areas. I mean, some people may have been more innocent than others of breaking the pudding when it comes to their applications out of desperation, but one way or another, HMRC doesn't want to be sat footing too large a bill when there are other parties to blame. Move on to the next slide, please. And just to finish the cover off Brexit as well, I won't cover it in too much detail, but it's still there. It's still being mentioned, as Michael said. It doesn't go a day in the news without hearing about a staff shortage or a supply shortage of some kind, which may be causing distress in your supply chains already, but certainly in places like the hospitality sector and the logistics and haulage sector, we already know is having quite big difficulties. Let's just hope that it's not going to ruin Christmas entirely. So move on to the next slide and get on to the more detailed stuff. So what are the warning signs of a distress in your supply chain? Wide, numerous, as you'd expect, sector specific to your particular industry and business. The sniff test, I always say, is in relation to suppliers and customers is their course of dealings, has it changed dramatically from how they normally acted or treated you before? Are they being evasive? Is there a significant change in their behaviours? You probably should assume, for the sake of your own businesses and your own supply chains, that the majority of people you're dealing with will have experienced difficulties as a result of COVID and or Brexit, and be alive to anything which sounds out of the ordinary for that particular supplier or customer. If you have invested in this sort of technology, there are various systems available which can give you financial information as and when it's available, depending on whether it's a listed company or just a private company, as and when accounts are released, as and when credit information is updated, for instance. If you have that technology, or if you're just an inquisitive person like I am and make regular searches of company's house to see what has happened when people have filed their accounts, then you should obviously be looking for companies which are highly leveraged, burdened with debt. You can naturally assume that they will come alongside large interest payments on a monthly basis, and that cash flow difficulties are going to be involved as well. Unsurprisingly, defaults in relation to payment terms or in relation to supply terms as well, I suspect, unless there is particularly good reason for it. People will often cite very vague excuses for why there has been a default on supply or payment. They may say COVID without giving any specifics. They may say Brexit without saying any specifics. But certainly defaulting on a regular basis is not ideal. Suggests that they are taking money from one party to pay to another, that they are living hand to mouth on a monthly basis, which does not bode well for their own their own supply chain, how they're managing their own customer and supplier relationships, and certainly your future relationship going forward as well. CCJs and credit information, similar to accounts information, if you have access to that. There are products like Tracker, for instance, and Red Flag, which are used quite widely in my industry, which are used to set up alerts in relation to specific clients or parties, so that as and when adverse information is released, whether it's CCJ, further lending, adverse accounts, winding up petitions, whatever it may be, then it will feed into those systems. They'll produce a metric score, a number, which will indicate that its fortunes are improving or declining. And obviously, the earlier you're able to preserve your position and protect your position when it's on the decline, the better for your purposes. High staff turnover or redundancies. So the furlough scheme has now come to an end. It's been a few months of settling down and getting back to what is the new normal in COVID. There have been some businesses have gone through various rounds of redundancies through the period of COVID, and you could arguably say that is reasonable. They may have reset themselves to a good level, but for cash flow purposes on a monthly basis, and are now able to trade profitably going forwards. Whatever the case, never ideal to see large rounds of redundancies, particularly now moving forwards. It suggests that their business hasn't bounced back from COVID as they would have liked. The staff which had previously been on furlough haven't had enough work to keep themselves to be redeployed, and we should be on the lookout for those sorts of issues. Staff turnover is particularly relevant if you're seeing senior members of staff, particularly finance staff, moving, being let go. It's never a good sign to see someone's financial director being let go, because it suggests that someone hasn't been carrying out their role, and if the finance director isn't carrying out his role, that can have quite serious ramifications for the business, clearly. Contractual changes, whether the party involved, the supplier or customer, has come to you cap in hand and asked for you to amend your typical contractual provisions, whether that's to reduce product standards or to extend payment deadlines or to reduce any other clause or terminology which you can tell is intended to reduce or make your position deteriorate as compared to theirs. Put it in a less certain position, for instance, than if they went into an insolvency process, then that should immediately spell red flags. Obviously, many of us will be aware of working with large companies who are endlessly pushing the envelope when it comes to their contractual terms and conditions, always seeing what they can get away with and pushing the problem of poor product or service delivery and payment terms further down the supply chain. But clearly, if you are dealing with parties who are further down the supply chain and are dealing with large companies in that way, then you need to be alive to that issue. And then generally, unreliable management, financial information. If you're faced with a request to change contractual provisions, or you are making inquiries following adverse financial accounting information, and the management or parties that are involved with and in discussions with aren't able to provide a clear explanation or make you feel much better about the situation very quickly, then that should immediately spell danger to you, and you should be looking at ways in which to put you in a better position in the event of something terminable like a liquidation administration. Move on to the next slide, please. Similarly, evasive finance or credit staff, where there's no clear explanation for a change in contractual relationship or a change in payment, or if the benchmark which you had set with this party a long time ago as being a regular payer and being a regular correspondent suddenly changes and there's no clear reason for it, then that should spell danger for you. Sector-specific distress, I'll leave you to decide what areas in your own businesses and your own sectors are liable for distress. But Michael mentioned a few that he'd seen which were liable to distress going forward. It doesn't take a genius to know that hospitality is still getting back on its feet. It's still trying to recover from a particularly bad 18 months. Anyone reading the news will have seen that shooting energy prices have led to an absolute car crash in the energy industry, with large companies, even large companies and small companies, going into insolvency processes there. Similarly, the construction industry and property industries are always very high in insolvency rankings in terms of companies that are adversely affected by insolvency issues, and their fates are obviously very closely intertwined with the state of the property market and fluctuations in the value of properties. Late company filings, not dissimilar from keeping an eye on Companies House and anything that's filed there. If their accounts are overdue, typically I would say 99 times out of 100 there's a reason their accounts are overdue. It's because they're nervous about releasing whatever's in there and setting tongues wagging and people making inquiries into the current state of the company. So definitely something to keep an eye on there. There is also the risk with late company filings and both accounts and confirmation statements that if they're not dealt with on time, the Companies House will dissolve the company, and the party which you've previously been dealing with, paying money to, contracting with, may no longer exist because they haven't dealt with their corporate governance very well. Announcements to suppliers, customers, shareholders or stock market. Occasionally you will see, well, certainly in relation to listed companies, you will see announcements of that type when there are serious issues around finances. Some companies, which are particularly diligent, will be forward facing and will come to suppliers and customers, particularly key suppliers and customers, and be very honest and upfront about what their issues are. And if you are in the privileged position of being one of those key suppliers and customers, then they are likely coming to you with a proposal which is intended to preserve that relationship and put you in a secure enough position that you are not concerned about continuing to supply with them. I can only hope that some of you are in that position and are able to have those useful conversations. Regular delays on delivery of service or product, I think we've already covered in the context of payment delays as well. Unusual activity on site or premises, you can probably categorise alongside evasive finance and credit staff, anything which looks suspect in terms of large numbers of people moving in and out, assets being moved around, can often be a sign of some kind of insolvency activity, process or restructuring, which is in the process of being formulated. And then, completely unsurprisingly, if they've come to you or you're aware of that they are restructuring or refinancing, that is something which is a clear indicator that there is something wrong. And we should obviously all be aware that refinancing covers a lot of ills. The vast majority of situations will start as a refinancing. They will go to a variety of other lenders. If they were previously with a high street bank, they'll move down one tier to a challenger bank. If they were previously with a challenger bank, they'll move further down to a debt fund or private equity. On each level, the value or the cost of that lending will increase. It becomes that much more difficult to service. And having a basic understanding of the kind of lending involved with your parties can give you an idea of whether they are on the decline again or whether they're on the up. Move on to the next slide, please. So what do we do? What do we do in terms of preserving our position and putting you in the best position possible? Obviously, look for the red flags, and then most important thing I would say is exploit any leverage that you do have. If you are, as I said, a key supplier, a key customer, and you're in a privileged position to be able to force that party to change their normal operating practices, to put you in some secured position to protect you in the event of any insolvency issues moving forward, then you should be able to have very fruitful conversations with those parties moving forward. I have seen instances where large sums have been outstanding to key suppliers, and they have used it as an opportunity to negotiate the purchase of certain of the company's assets. In one case, a property, a freehold property, which they were occupying as part of the business, and then entered into a sale and leaseback where they took the property in lieu of their debt and then leased it back to the company in order to so they could carry on trading and had an income coming from that property, which sounds like an extreme example, but if you're in that privileged position where they have very few other people to negotiate with, and there is already a large liability, and the option is that or liquidation administration, then many people will want to negotiate on that basis. In terms of other leverage, I would say this because I'm an insolvency solicitor, but we can normally engage from your story, the way you explain how a trading relationship has deteriorated, or how they are now communicating with you, what language they're using, for instance, that whether or not that party is already considering some form of restructuring or some form of insolvency process. If that is the case, then there are ways in which that we can put ourselves high on that high on the agenda when it comes to any negotiations. We want to look at your contractual terms and conditions. We may suggest that you stick a winding up petition in immediately, which means if they are trying to structure or negotiate some kind of sale or restructuring through administration, or with a company voluntary arrangement, for instance, that they will need to dispense with your winding up petition before they can put that into effect, which puts you in a fantastic position when it comes to negotiating. One thing I would say is, having dealt with the post-COVID world and how the government is encouraging us all to foster this spirit of togetherness, and that we should all be negotiating and talking to each other on a regular basis, considering forbearance and restructuring, refinancing debts, that kind of thing, is you are perfectly entitled to be selfish as well within the realms of the new legislation which is being developed. It is all well and good saying, we're all in this together and we'll try and be as helpful as we can. But if you're the party that's left lumbered with a £300,000 liability, or worse, if the goodwill of your supply chain is damaged because of defaults and missing supplies and services, then you will probably at that stage wish you'd been a bit more selfish about how you take enforcement action. Number 2, contingency planning. This is all obviously forward-facing, is to have a look at your supply chain now. As I think Michael mentioned, that the lingering doubt of another lockdown hasn't gone away. The prospect of something like this happening again in an increasingly crowded world with planes flying all over the place, we can't discount this all happening again. So if nothing else, in order to preserve your position and have you in a good position going forwards, it would be sensible to look at your supply chain. Who are the key suppliers, key customers, how the contractual relationships work at the moment, and really getting ahead of any future problems. Number 3, ongoing stakeholder management engagement. This is one of those things which sounds very obvious, but having clear lines of communication with these parties, with your senior management, with their senior management, and goes hand in hand with the red flag of worrying about evasive suppliers or customers. If you have clear lines of communication and you're able to have a fruitful conversation about how those parties can continue trading, even if there are concerns around the solvency of those parties, then that's certainly to be encouraged, I think. Number 4, consider your rights on insolvency, and I would say in particular to know the difference between a company voluntary arrangement, an administration, and a liquidation. A liquidation obviously is terminal. It is the end of the business effectively. All contracts are terminated, whatever assets are left in there will be sold by the liquidator, and if you're a creditor, you'll get a slice of the distributions that they receive. And I think, on average in a liquidation, a few pence in the pound is what you will receive through a liquidation. Administration has a wider range of outcomes. Some will be akin to a termination, to a liquidation, but they use the administration process to wind down ongoing contracts in a more in a cleaner and more profitable way. Some will be genuine attempts to save the business, either by refinancing, restructuring, in the hope that it can exit administration and carry on trading. And then a company voluntary arrangement is obviously is effectively just an agreement with the entire body of creditors, where everyone gets a vote, and it is only passed if the majority approve it. You can obviously, hopefully, tell from my brief description that your position is going to be significantly improved if there is concern or a suggestion that maybe administration or a company voluntary arrangement is being suggested, than if there is suggestion of liquidation, or worse, if a winding up petition is already pending. In relation to winding up petitions, it's worth noting that when a winding up petition is pending, the company which is subject to the winding up petition, in case it's someone who's paying you money, isn't technically entitled to distribute, make payments, to sell assets, to distribute assets or property at all, because in the event that a winding up order is made, all the transactions between the period of the petition and the order are void. So if you're dealing with a party which is subject to a winding up petition, you should particularly have care for any sums of money you receive there, where they haven't been specifically authorised by the court. Very, very important issue, and lots of people find themselves having taken money without knowing anything about the petition, and in good faith, in the ordinary course of business, to pay down debts or to pay for new goods and services, that they end up having to repay those to a liquidator at some point. Drafting of commercial terms and termination provisions is very important. Whether you're supplying goods, the strength of your RRT provision is going to be very important when you're negotiating with a liquidator. Equally, in relation to supply, anything where you are paying for goods or services in advance, and the party is holding sums of money on your account, is worth having a review of your terms and conditions there. Keep control and take action quickly. When you see those red flags, it's very important that you take advice and consider the best way in which to respond and deal with those situations. As I mentioned, it may be that you look at using an insolvency process yourself to put you in a good position. It may be that you are looking at the future trading relationship and how you can use leverage there. It may be that you're looking at your new revised commercial terms and termination provisions to put you in a good position as well. But all very important. Close control of finances and debtor ledger, again, fairly obvious. One of the benefits, I think, of COVID was that everybody became very much better at controlling their debts and recovering book debts than they were before. Obviously, cash is king, and they were parties, understandably, during a lean trading period, very keen to make sure that cash was coming in on a regular basis. And I imagine debtor days across the board have probably gone down quite significantly. Long may it continue, but certainly not allowing old debts to linger and become, fester, and the knowledge of what happened, who paid what, who said what, once it becomes old and a bit stale, it often becomes a bit more difficult to recover. So worth keeping on top of those sorts of things. And then finally, just early and ongoing due diligence at all times, where I mentioned you understanding and knowing your own trading relationships. Set a benchmark. Maybe this is the time to reset your supply chain and say, right, well, how are we trading with these parties now? How are they going? How are the relationships? Are they strained? Are they productive? Blah blah blah. And then setting a benchmark so you know where that relationship goes going forward, particularly if there are any further lockdowns or other areas of distress, and that will certainly put you in a much better position to understand and spot significant and important changes in your supply chain. But for now, that's everything from me. Thank you.